But today she's also going to share a lot about your questions on wills, trusts, estates, and all the things you might need to know.
Perfect. Well, like Molly said, I'm Wendi Efflandt, and I have been practicing here in the Central Texas area for coming on 28 years. Heritage Law was formed in 2000, so we're just coming up in July on 26 years here in this area. About me, my husband was in the military for 34 years. He retired a couple of years ago. He's now in administration at the Texas A&M in Central Texas because he bleeds maroon wherever he is. I have two adult sons who both just graduated from college within the last 4 months. So that's awesome. So just before we get started, I just wanted to kind of give one sort of universal apology. I know that a lot of people here, or somebody here, may have recently experienced an illness or a passing in their family, and so I'm going to be talking. I try to use things like we all got on the Titanic or something like that, but if that is something that you're going through, I just want to say that I don't mean to be blunt about it or insensitive, so I'll try to be as sensitive as I can, but I know that sometimes when we're talking about this stuff, it hits home for some people. So like I said, we're Heritage Law, and we have an office in Georgetown. We also have an office up in Bell County in Harker Heights, and today we're going to talk about some of the common mistakes or misconceptions that people have when they are talking about estate planning or probate or things like that. So we'll go ahead and get started. Let me see if I can remember how to. So, number one, my spouse has died, but I don't need to probate their will because both of our names were on everything. It's a really big thing that maybe in some other states that's the case, but I get lots of people who, their spouse passed and they're allowed to live in the house forever because that's the Texas law. We have a constitution that says the spouse can reside there. But when we write a deed in Texas, there's no presumption that just because two people are on the deed at the time of someone's passing, that the other person gets it. And so that something needs to be done. And we have 4 years in which to do it. Okay. And so just if you hear of that, or if it's your, hopefully, but, friend, parent, neighbor, what happens is that if we either don't have a will or we let it go past 4 years, then Texas starts to tell us what to do and we don't get to pick. And so we don't want that to happen, especially if you already have a will. And so that would be not a good thing. So, another one that we get very often is, again, we both have our names on the house or on our accounts or on everything, and so we don't need a will. And again, back to, we don't have any kind of right of survivorship here in Texas. And so if you don't have a will, then the estates code is going to, again, tell us who is going to get that. I'm going to show you the intestate succession charts in a minute, and a lot of people are super surprised by what they say. On top of that, we just don't know. Like, there could be, hey, there's a refund coming from a year paid on our home insurance. There's, unfortunately, like a claim, someone had an auto accident. It might be why they passed, and they want to, pay this money to the estate, but who is that? And so I've had a lot of people that come to me, and someone has already passed, and unfortunately, they don't have a will, and then I have to show them this chart, which we're going to look at. Married person who has children at the time that they pass, if they have separate property, so separate property might be something that I have, like that I had before marriage, or maybe I inherited some funds from my parent and, have them in an account, or maybe I inherited some real estate, like Grandpa's ranch, okay? So this top one, if there's money in a bank, it is 1/3 to the surviving spouse and 2/3 to their kids, okay? Kids may be kids of this marriage. Kids may be kids of a different marriage, okay? Because they might have kids from before this marriage. So sometimes the surviving spouse is like, what? I only get 1/3 of what's in this, investment account that we've been using from, our mom or whatever. Real property, the surviving spouse gets a 1/3 life estate. And if you can figure out what a 1/3 life estate is, I would love for you to tell me, because I'm an attorney. And it's like, is it a life estate of 1/3 of the property, a life estate for 1/3 of your life? Anyway, it's a problem. And the remainder is going to go down to those kids again, whether they're kids of this marriage or whether they are not. This one is where everybody's like, oh, wow, this is shocking. So if all of the children are from the same marriage that the decedent was in at the time of their passing, then the community property, which is typically our homestead that we bought during our marriage because we bought it together while married, is going to go to the surviving spouse. The problem is if we have children that are from a prior marriage, and again, we haven't written a will, we haven't said what our preferences are. So the law decides for us that all of the children, whether they're from this marriage or a prior marriage, or whether they're the adult child we haven't talked to for 35 years, become half owner in the decedent's half of the house. So again, just because we have two names on the deed, two names on whatever it is, please don't presume that that means that the other person gets it. And we don't want to get into a situation that we didn't anticipate. So, all right, next one. I wrote my own will, so I don't need an attorney to help me. Maybe they hand wrote it and signed it. Maybe they drafted it themselves or had it notarized, or they used some kind of online service. So the thing is that by the time we figure out that there's a problem, usually it's because somebody's passed and it's too late to fix said problem. Okay, handwritten, it might work, but the thing is, it's going to be really expensive. I have to go get witnesses as to your handwriting and bring them, and I have to go get people that, so, there's a lot of things that also could be missing. Maybe they didn't name an executor, so now we don't know who's in charge, or they didn't give away all of their estate. They start writing things down, this account or that account or this house or whatever it is, and they've left an asset out. So not only then do they have to pay to have this will probated, but they also have what's called the intestate succession, because there's no will about that other thing. So we're back to that chart with the pie graph that we just talked about. And now they're paying for two processes because they wanted to just write their own handwritten thing. Typed and notarized. Like, I can't tell you how many times people bring me a piece of paper and they're like, this is my whoever's will, and look, it's notarized. So in Texas, you have to have two witnesses. Like, the notary is one. So then I have to tell that person that is not a will, and then they get really mad at me. I didn't even write it. And then we're back to that pie chart, and again, unprobably expected potentially result because they decided they would just, type it up. And then again, online wills, they may not even be coming from Texas. And if they're not correctly witnessed and correctly notarized, even though they're maybe have good provisions, then the court's gonna say they're void. So I've had people where they had like their child be one of the witnesses, and there was a gift to that child in the will. And if you have that child as the witness, then it voids their gift, So, or again, somebody signed on one day and somebody else signed on the other day, and it has to be in the presence, and it's clearly dated like a different day. And so, what I would just say is that the little bit of, again, it can be to some people. I'm going to say it's inexpensive, but the amount that one might spend to make sure that they have a correct either will, trust, whatever kind of thing that you want to do. I think you're going to be spending less now, and also than you might on some of these other things. And also you're getting the result you want, because I tell people your failure to plan, someone else will plan for you. And you may or may not like said plan. So that's about that. My loved one has passed. They have a will. I'm the executor. We don't need a probate. So when you have a will and someone has passed, you have a piece of paper that purports to be a valid will. If I take that over to Bank of America, for example, and I say, hey, I'm my dad's executor, he had an account here, here's the will, Bank of America is going to say, well, we don't want to be in charge of, we don't know if that's right, we don't know if it's got all the whatever, etc. And so basically they're going to say, hey, you need to take that to court. You need to have it probated. The great news in Texas is that we have a super easy probate system as long as we ask for it in our will, and we just have to go to court one time. We don't have to post bonds. We don't have to have appraisals. So there's a way to make that probate very easy if we ask for it in our will. So probated, I just wish we'd use a different word because it's such a foreign word. People are like, it just means approved. I want the court to approve this will, okay? I want them to say, yes, it is a valid will. Yes, it has the 2 witnesses. Yes, this person has passed. Yes, I am the person that's named as the executor, and now I am appointed to be the executor by the court. So non-probate assets, I don't know how to make my little thing show down there, sorry. No, maybe it's the wrong size of screen for it, but anyway, non-probate stuff. So when someone passes, we're going to have 2 categories of property, okay? Probate is probate property or non-probate property. So if I say it's probate property, I'm looking for a will to tell me what to do with that property. So again, that real estate we talked about. Maybe there's some other bank accounts that have their name on it, no other name, no other beneficiary. So again, they're looking for the will. But I can also have things like, say, a life insurance policy. I, made a contract with MetLife. I pay MetLife $100 a month forever. And I can say, when I pass, I want $100,000 to go to person A. So that is a contract. They are not going to care what I write in my will. They are not going to care what you write in your will, or whoever writes whoever. It's going to happen according to that. That's going to take precedence over this. So that's something a lot of people don't understand either. They'll have gone way back before maybe they got married, and they have their brother, as the beneficiary. And then they've gone and they've gotten married, and then they wrote a will, but they never went to Fidelity and told them, hey, I need a new beneficiary, which is, my spouse. So we can, put beneficiaries on accounts, on policies. If you have a checking account with your spouse, you may have what we call rights of survivorship. You might see a designation on your account that says JWROS, which is joint with right of survivorship. So that means if one passes, again, contract, we're going to go to the other person. We're not going to need to look at the will. There's also things like transfer on death deed, or what you might have heard as a ladybird deed, that kind of thing. That is something that we can draft. And again, I'll show you, we'll have some more misconceptions, but probably best to have an attorney to draft that because it's real estate. And do we want to cloud the title to our $500,000 home? Probably not. So you can have that kind of a deed. And then in that case, that means we've both signed it and we've done a special beneficiary designation into the deed record. So that's different from just getting, when you buy a house in Texas and you come to a lovely title company like this, they're going to put husband and wife's name on there, but they're not going to get involved in estate planning because they don't know who your family is. They don't know who your kids are, because people are like, why don't they just put it when we buy it? Because that's not their job. They need to investigate, so when you meet with an attorney, we're going to find out who are all your family members? What do you mean to have happen? And then you could potentially put some kind of beneficiary on real estate. Okay, so that would be how you would do it. I don't need a will because I drafted and filed a transfer on death deed, and again, I have all these beneficiaries. So a transfer on death deed might be a good idea in certain situations. Like someone came in the other day and they were like, oh yeah, we did a transfer on death deed, one house to our one grandchild and one house to our other grandchild. And I was like, awesome, how old are your grandkids? And they're like, one's 12 and one's 14. Right? I mean, if you pass 2 years from now, which they could have been the age to do that, this is a minor.
Yeah.
I mean, they're not going to be able to transfer the property, manage the property. I mean, all kinds of things. So also I have people that'll say, yes, I did a ladybird deed to get another kind of transfer on death deed, and I left it to my 6 kids. Okay, when you write a will and you name an executor, it's sort of like you appoint a president of your estate. If you do a transfer on death deed to 6 people, those 6 people own that house together, and there's no loss. So they all 6 gonna have to, figure out what realtor they want to use. They all 6 need to figure out the sales price. They all 6 need to figure out if they want to put new flooring before we do the staging and where's all that money, like who's pitching, and if all 6 of those people don't agree, we can get into a really big stalemate type of situation. So again, certain situations, probably not a good idea. I have people that want to leave different percentages. I just had someone yesterday that said, I want to leave 40% to 60. Deeds are not for, hashing out percentages at passing. It's not a good way to do that. And then also, sometimes when we have people that do transfer on death deeds, they don't do any kind of alternate beneficiaries, contingent beneficiaries. Then this beneficiary has failed. They actually didn't outlive you, and you forgot to go change it or do something else. And so it just makes something really complicated, which again, we probably can do some will or some trust or something else that actually spells out a little bit more about your wishes so that we don't have kind of a train wreck if something happens. So. Okay, I don't need a medical power of attorney or a durable power of attorney because my spouse can just decide his or her name is on everything. So Texas has no presumption that anybody can do anything for you without some kind of what I call written permission slip. So we have got to give permission slips to, our people. Yes, maybe you're both on the joint checking account. Awesome. What happens when it's time to, maybe one of you has, lost capacity. Maybe we need to downsize. And we get over here to the title company and they go, yeah, who's going to sign for John? And there's no durable power of attorney. There's no written permission slip. There's no anything. And then we are going to have to file for a guardianship in the Texas court. That is thousands of dollars. There are bonds. There are yearly accountings of every dollar that is brought in on behalf of the ward. And the court has to basically approve, it's Mother May I. Mother, may I sell this house for this person? Do you think that's a good idea, court? And so, the filing fees alone for a guardianship are over $1,000, and that's the court fees. That's not even attorney's fees. So, that durable power of attorney, or you'll hear statutory durable, but a financial or business power of attorney. I'm giving a written permission slip. They might need to file. I'm still living. I have tax returns. Can't just sign someone else's tax returns. Different types of things that they may need to do for you. At a bank, financial institution, credit card company, like I said, tax returns, insurance. There's just so many things that if I'm alive, but I can't do that for myself, are not going to get done if I don't have, that in place. Same thing for medical. In an absolute emergency, are they going to probably let your spouse, consent to your treatment? Yes, but again, we have all kinds of situations. What about if it should be, I'm single and that should be my adult child, but I have 5 kids? Well, which one? Which one is going to make a medical decision for you? Or, again, a lot of different scenarios with that. So, also, a good medical power of attorney is going to have that HIPAA release in it. So, the privacy policy that we talk about every time. So, in COVID, I had a lot of people who had some medical power of attorney that they got from somewhere, but it had no HIPAA release. So, when they went to the hospital without their person, and then when that person was calling, trying to make medical decisions, they were like, we can't release any information over the phone because you don't have a HIPAA release. And so that, just having those in place is going to save us a lot of problems. Also, I know this sounds silly, but you've got to do it before you need assistance. I can't tell you how many people call our office and they're like, well, my mom now has dementia. She can't do this. So can I get a power of attorney? That's not when it happens. That's too late. And so we got to make sure at our office, we don't draft any powers of attorney for anyone who we don't actually meet with and assess. And then if we have any issue, any indication, we have to have them go get a physician to then tell us, because I'm not a doctor and I'm meeting with you for 30 minutes. Obviously, it's usually pretty obvious that you have it if you have it. Sometimes if they might be just, a little forgetful, we're like, let's get some verification here. So, but it's once you're incapacitated, it's too late. So we don't want that. Let's see. So that's just a little bit about sort of just some of the things that people, like I said, are most surprised about when they come and talk to us. But I'm happy to, if you have some questions that came up as we went through the slides. If you've got questions, I don't know what the timing is or how long I have,
Yeah.
or whatever. So, but
Thank you. I'm glad you're open to questions.
for sure.
And
Yeah.
so I would love for anybody to ask any questions. And again, if you have to slip out, do that. That's no big deal. I'll start us off. One, when you have that situation where you're in the office and you're not quite sure about it, if the physician says, nope, cognition's gone, then it goes into that guardianship.
Correct.
situation.
Yeah, I'm not able to help them at that point. And I also get like a lot of, and of course my dad currently has dementia, and there's a lot of things I have to take care of, which I have a power of attorney for.
Yeah.
But I get a lot of people, they call our office and they're like, hey, I need to make an appointment for my parent, and et cetera. And so a lot of times we have to say, okay, that's great, but they're going to have to call if they have to have the capacity to make an appointment, come to the office. I mean, you can drive. Sometimes they can't drive. That's okay. That's not capacity. But we don't draft any documents unless we have laid eyes on the client and had a discussion with that client. Or someone's like, oh, can you draft a deed from my mom to me? And it's like, well, no, your mom can call us.
Right.
And your mom can come and meet with us and tell us what she wants, And so we have to be really careful. But yes, unfortunately, if they can't bring back that statement, that means that person that's trying to help them is probably going to have to get, and guardianship is just so, unfortunately, accounting oriented. I am not the biggest numbers person. My office manager has worked for me for 27 years, and she does all the numbers. And so they're really more accounting. I mean, so so we refer out our guardianships if they have gone. We try to prevent guardianship.
Yeah.
But that is kind of a special niche, just because it is just so report intensive.
Yeah. I can imagine.
Do you often, do you see different people being medical power of attorney versus durable power of attorney?
Yes.
And do you recommend that, or what do you typically recommend? Or it just depends?
Yeah. So every people ask me, oh, should I have this document, that, what should, and I always have to say, we always meet with our clients and find out what their family situation is. So I'll give you an example. I mean, I have a spouse, so he's my medical and he's my durable, but my sister-in-law is a nurse. So she is my alternate medical power of attorney, because I don't want anybody else making a medical decision for me but her.
Yeah.
Two, I hate to say it, but my younger one would be first every time. And it's just, they have different talents, right? They have different, responsibilities and things like that. So you really want to think through it. 100% could be the same person, but it could be potentially two separate people. And if so, that's perfectly fine as well. I find it's not always, but if the medical power of attorney lives closer, it tends to be easier, because they tend to be the one that deals with taking to appointments, if that gets to be the point, and that kind of thing. Whereas I see that financial power of attorney can be done from afar. It's still not easy, but a lot of this DocuSign and email and, FedEx if we have to. But so that can typically be done a little bit more remotely. And not to say that you can't have somebody as your medical, all things being equal, I would definitely look at having the closer in proximity person if possible. So, yeah. Any other questions on?
Will you touch briefly on will versus trust, and when you might look at one versus the other?
Yeah. So basically, we talked about having a will. When we have kind of a path, durable for finances, directive to physicians, which is what you probably heard of as being called a living will. And that is, hey, one day down the road in the future, if I am in this irreversible or terminal condition, I am going to choose for my people whether I would or would not want to be on life-sustaining support. And then the last one is going to be declaration of guardian for the estate of person. And I have a brochure over here. I see some people writing, but this has all of them listed in there, so you don't have to write it all down.
They're all like, oh, okay, good.
If I give it to you ahead of time, then people are like this. So I don't give it to you right now.
That's
But you're going to get it in just a minute, so don't worry. And it's also on our website. If you heritagelawtx.com, but anyway. So the declaration of guardian for my estate and person, there's a few of our little federal entities, Social Security, Medicare, Medicaid, VA, if you're involved with that, and they get hung up on the term guardian. And remember how we don't want to go to the courthouse and have that. So we will just declare, hey, if you want to call the person guardian, here's their name, number 1, number 2, number 3, written, permission slips. And I want to emphasize too, like we talked about with wills, there are certain requirements for witnessing and notarizing all of these. So again, and I'm sure Jennifer will attest to this, but on a statutory durable power of attorney, there are lots of choices. And when a client meets with me, I go through, do you want them to be able to transfer real estate? Do you want them to be able to have any compensation? Do you want them to be able to give a gift? I mean, and so there's some of these where I had somebody, they got it off wine, and they just signed the bottom, and they didn't choose anything. And so essentially, they have appointed a person who has no powers. So that's, again, the kind of conversation and advice that you're getting. It's not just a document. I mean, it's, hey, let's talk about your family situation. And again, like, do your kids get along with each other? I know we're back to trust in a minute, but I would get, I want to make, 2 or 3 of my kids co-executors. I would highly not recommend that. If you make 2 people co-executor, number 1, there's no tiebreaker. So if there's a stalemate, there's no action. Number 2, it's not an either or, it's a both and for most things, like in an estate, like especially for a probate. And so they both have to go to court. They both have to do the closing. They both have to come to the attorney. I have a policy when I have co-executors, I cannot even talk to one of them on the phone unless we're all 3 on a conference call. Because then they're like, I talked to the attorney and she said, and then why am I not, and so it's going to be pricier and it could be super complicated. So anyway, but back to, so that's kind of like at a minimum, I would say everybody needs to have those. If you own property, if you have children, at least cover yourself with that. And like I said, we talked about some non-probate things you can do, with beneficiaries, or maybe a transfer on death deed is a possibility for your family. Like, we'll talk about that. When you create a trust, basically, I use the analogy that we're kind of having a container where we're going to place our property, as opposed to just having it in our own name. And in fact, let me switch to a different PowerPoint really fast, and I will see if I can. It'll let me. I'll show you my living trust explanation because the diagram makes it look really easy. There you go. All right. So I use the analogy of a wagon. So basically, instead of me carrying my property in Wendy's name, I have created the Efflandt Family Trust, and so that is this entity down here. And then typically, if there's 2 spouses, they would be co-trustees. So we're still driving the wagon. It's still our stuff. We've just chosen to carry it in this manner. So the trust agreement is a contract that you're writing during your lifetime that says, hey, anything that we choose to put into this wagon is going to be governed by that document. So it's no longer in my name, it's no longer my will, any of those things. So what happens is if something happens to me, well, then my spouse is still there. They're the successor trustee. If nothing is in Wendy's name, Wendi doesn't need a probate. Wendi doesn't own anything in Wendy's name. Wendy's house is in there, accounts can be in there, beneficiaries of a life insurance policy can be the trust, that type of thing. So then it says, hey, if I'm not here, my husband can carry on. And then what we're gonna have is, sorry, I'm like looking backwards and upside down, is that when both spouses are gone, we're gonna have in that trust agreement, hey, who's the successor trustee? Again, trusted adult child, sibling, whoever it is that's going to be a responsible human. And then the trust agreement is going to say, hey, anything in the trust is going to be split up however that is, okay? Now, this little diagram over here, when you do a trust, you still are going to have something called a pour-over will. I call that a Band-Aid document. So it says, hey, I meant to have everything in my living trust, but if I forgot and I have something that I left in Wendy's name, I want to pour it over into the living trust, right? So I don't want to get a cut, but if I get a cut, I'm going to use the Band-Aid, right? So if I have to use the pour-over will, it needs to be probated. So remember how we did this whole entire thing, trying to basically avoid probate. And so we still have it, but I have this little symbol like that because it is like, no, we don't want to have that happen. So what I would say specifically is, if you're not a super detail-oriented person, you know, then you may want to think about, you know, are you structured for this? Just because every single account has to be a beneficiary or has to be in the trust, all the real estate in the trust. You know, you may, if I have a couple sitting there, I'm like, honey, well, what about that one account in Oklahoma? Remember when we bought that car? And I don't, yeah. And they're like, don't even know the institutions where their accounts are. I'm probably not going to tell them to make a living trust because they're going to pay more because the living trust is more upfront because we're trying to avoid 2 probates. Remember, the probate of the first spouse and the probate of the second spouse. And so, you know, it's a little bit more now, hoping to have nothing later. A will is going to be less money now. I would say probably somewhere between, probably about 40% of the cost, ish, you know, now. But, you know, just depending on how everything else is structured, I might have to probate, maybe not with the first spouse if we do a lot of beneficiaries, maybe we have a transfer on death deed. But when the second spouse is gone and we still own that house or whatever, then a likelihood is, unless we have an only child, then again, we've done another transfer on death deed, but if we have 5 kids or whatever, we're going to need an executor. And so they're going to pay for the probate process 20 years from now, hopefully, or, you know, whenever it is that we're going to get to that point. So, there's no one size fits all to me for everybody. I really think that you just need to have a conversation of what is your family situation. What is your property? So, for example, if you own a property in Texas and a property in Colorado and a property in Florida, I'm going to go, oh, you should have a living trust because if you pass, we have to probate the will in Texas, California, or Colorado, whatever state I said, and Florida. So again, I could save myself 3 probates, right? If you have a child or a beneficiary that's super disgruntled person, maybe, you know, whatever, when you have a living trust, it operates completely outside of any court. So there's no platform. There's no place for that child to even start to file. You know, and of course we're going to put no contest clause in your will and your trust, but just there's not even like a platform there. We aren't even at court. We're totally outside of court. I always tell people the good news about the living trust is that you're never going to be in court. You're not going to be court supervised. The bad news about the living trust is you're not going to be in court. You're not going to be court supervised. So, I mean, whoever that you pick as your trustee, I mean, when you have faith that that person is going to carry out, you know, that trust agreement. This trust agreement is completely also changeable, revocable, amendable by the spouses while they're alive. But once they do pass, it's irrevocable. This is the marching orders, you know. So as long as you could keep everything in there, then I think that could be an economical and efficient, potentially, way of handling, you know, your property. But what we do is we just lay out all the options for you. And, you know, some people they can take that out of my vacation fund when I'm done vacationing at the end. They can pay for the probate then. It's kind of like funeral expenses, you know. Do I go now and do I pay for all the planning and all that kind of stuff? And it's probably like less now. And then hopefully 20 years from now, I've already bought it, so I've saved this money. Or do I just go, you know what, that'll just be like a funeral expense. Take it out of my Chase Bank, or, I mean, you know, whatever, something like that later. So did that kind of
that was great.
answer?
And when there's 2 spouses that have the revocable trust, once one passes, can it still be changed?
That's the conversation. Okay. And so, for example, if it's a non-blended family and that you have the same 2 kids and you've been married for 60 years, you know, do we say, hey, you know what, let's let the surviving spouse have flexibility. Just in case little Johnny runs off the rails 10 years after mom passes, I might still want to like change that and say, wait a minute, Johnny needs a trust and needs a trustee, or maybe it needs to go to Johnny's grandkid or kids. Yeah. And so, you know, and so I always tell people, you know, there's 2 options. You could say, no, I don't want to ever change after the first person passes. So that's a drafting, that's a question. And so I had a lady who they had irrevocable on the first death. She outlived her husband by 17 years and 2 sons. One was stealing copper off of the back of her house to buy drugs. And the other one was mowing her lawn every week, taking her to every medical appointment and doing all the things. And so what we were able to do is we were able to withdraw her half but we had to leave the other half in that trust because it was irrevocable.
Got it.
And so, so that's a question you have
Yeah.
to talk about is, do we want it, or we also have a process of where it could split into 2 wagons, and one's the deceased wagon and one's the survivor.
Got it.
And the survivor still gets to do whatever they want with theirs, but the deceased is still irrevocable with Johnny and the copper, so.
Right. Right. Got it.
Yeah.
A lot to think about. A
yeah.
lot to think about.
Yeah, and that's again why when people I'm are just clicking things on. I had some people that came in and they had, oh, can you look at our legal Zoom list? And we don't really do that. Actually, that's not really part of our. But I said, just one day I was like, fine.
Let me see what that looks like.
So he had 2 kids and she had 2 kids, and they wrote their legal Zoom wills, and it said, hey, if I pass and my spouse is living, give out all to my spouse. And then it said, hey, if my spouse has already passed, give it to my 2 kids. And they both said that. And I said, okay, well, you know that whoever dies first, their children are getting nothing. And they're like, no. When the other one dies, it's going to go like, and I'm like, no. You said if my spouse survives me, it's all to them. That's over. Then this person's will said, if my spouse didn't survive me, it goes to their 2 kids. So the way you have this structured right now, whoever passes first, their children will get nothing. And so those are the kind of things like we want to think through the big picture and kind of figure out, like what will happen and how you want it. And, do we want flexibility? I would say the good news is the surviving spouse has flexibility. The bad news is the surviving spouse has flexibility. Are you, And so those are just all the kind of considerations that you want to look at and again, not fall into one of those pitfalls and, have something unexpected that wasn't what you wanted.
Yeah.
So anything else? Anybody else questions?
I have a dumb question.
Yeah.
Dumb question alert. So trustee is to trust as executor is to will.
Yep, exactly.
Outside of those, you would still need a medical power of attorney and durable power of attorney.
Mm-hmm. And actually, there's 4 things that I mentioned, and so in here it has all the 4 that we recommend: that living will, and then the declaration of guardian.
Okay.
Yeah. So will or trust is going to be for property upon passing, and then the 4. And then also, I didn't mention. But we also would have. If you have a minor child, appointment of guardian for minor child. And I do that in a separate document. Some people put it in the will, but the thing is that I could be incapacitated and alive, and then my will is not in effect yet. So we do that in a separate document.
Smart.
Because I have actually had parents where one has passed and the other incapacitated, and so we still need to appoint somebody to help grandma, grandpa, sister, brother, So if you have a minor child, I would add that one more to the total package. But yep, trustee, trust. And then if you hear the word administrator, it means that somebody didn't have a will. Because executor is to will. No will, they appoint an administrator because that's the title of the person that gets to be in charge.
And how do they determine that?
Everybody either has to agree that are the beneficiaries. Fun. Or then there gets to be what we call a dependent administration, and that's what I call another may. It is where literally whoever finally gets to be the dependent administrator must ask court permission for, may I sell the house? May I sell a car? May I pay the attorney? May I pay the utility bill? And it's, when I say thousands of dollars, like really, really, I mean, tens of thousands of dollars. And so unfortunately, again, with that no will situation, it can turn out if we all get along and, hold hands and sing kumbaya, it's still expensive, but not crazy, but it's especially when you maybe have a spouse that's not the parent of these 2 kids, and maybe there's not a trust there or whoever, and nobody can agree, and so then it can get crazy. No fun.
I have kind of a morbid question, but we're talking about heavy things, and that wasn't a stupid question.
That was a really good question.
We are an only child family, and he's turning 18 next week, and clearly what would make sense is we leave everything to him, right? Which is what he hopes that we do.
Yeah.
So to be determined. I'm just joking.
Yes.
And my dad used to be so concerned about this our whole life. He would never want all of us to travel together. Right. And so, but we travel together all the time. What if he's 18, and we're traveled together, which we do as a family all the time, and God forbid tragedy happens, and tragedy does happen, and none of us survive.
Yeah.
what happens to the property, to the finances, to all of that
Do you have
stuff?
a will or you don't have a will?
I do have a will.
Okay, so in any
But
will that,
he's, well,
Yeah.
I,
any will that we write, we have what
He
we
would be
call
first,
the
and then-
remote contingent disaster. I call it the
Yeah.
Titanic provision.
Yeah.
We all went and got on the Titanic. And so we have like typically just one of the kind of, and I don't know what your will is, obviously,
Yeah.
but sometimes it says we'll find the closest heirs of husband for 50% and the closest heirs of wife for 50%,
okay.
which typically would probably be a sibling at your point. No, you don't have a sibling. Are you?
No, I do have a sibling. We
Yeah.
just only have
Okay,
one
so
child.
for
Yeah.
the adults, it might be a sibling, and then for your child, it's the parents, so that's going to flow back out. So
Yeah.
sibling, niece, nephew,
Okay.
eventual cousin.
Gotcha.
So we always have some, but some people will also say my remote contingent disaster provision is the American Red Cross and my church and
Sure.
my.
Yeah.
So then they just liquidate everything and they give whatever funds. Okay,
So you
I
can
just
pick-
That's cool.
had no idea.
Yeah, you
Okay.
can pick. So that's why I was asking, do you or do you not have a will? Because if you
Yeah.
don't have
Yes.
a will, we'll go back to that chart. And I didn't go down
Yeah.
all the way to unmarried people with or whatever. So,
Okay.
but it would go according to that. But if you have a will, let's talk about. And I do. I say, hey, if you were to all,
Mm-hmm.
also just to bring up for your son, in all of the trusts and wills that we write, we'll have what's called a contingent trust. We'll pick an age, maybe 25,
Maybe 45,
30,
yeah.
35,
I
40.
mean, it's-
Yeah, and it'll say, hey,
Fair.
if any beneficiary is under the age of 40,
Yeah.
then my executor will then become their trustee. They can have distributions at any time for health, education, maintenance, support, things that are a good idea. But when they say a really good idea is for me to drive a Ferrari to UT, the person would go, no, but how about a Honda Accord?
Yeah.
That's a 2017 or whatever.
Yeah.
So they will have access potentially to the money if needed, but they're going to have and I have again people that wrote it online and they're like, oh, I did a contingent trust till they were 18, and I just probated one, and the kid got like $55,000. He bought a $49,000 Mustang, and then learned that it was going to be $522 a month to insure said Mustang, and then the Mustang had to be traded in 2 months from
Yeah.
and then he lost.
Lost
$20,000.
it.
Money. Yeah.
And so the 25 is kind of usually my kind of a minute, because people are like, I don't have any people that are 20. But thinking forward, let's just say that we go another 15 years,
Yeah.
and then you get on the Titanic, but there's a 4-year-old grandchild. Well, we've got that covered because they're like, well, my child's already over 25, right? But we don't know who could end up being a beneficiary.
Yeah.
So we just pick an age and we say, this is the age we think these people might have good sense.
Okay.
And we put that in almost every single will or trust that we have, just because we don't want to have a situation where a minor gets something, but B, a 19-year-old gets $1 million and then goes crazy. So, don't want that.
Yeah. Thank you.
When she mentioned almost 18-year-old, will you speak a little bit to your young adult provisions, right? Because they become adults, right? They need to have
So we do,
something
especially for existing clients of ours, if you have young adults that are about to go to college, we usually have like a little college student kind of special, where we'll do a durable power of attorney and a medical power of attorney.
For young adults?
18.
For 18?
Yeah. And because guess what?
Yeah.
A bunch of parents.
They're adults.
I'll give y'all an example. I took my son on a ski trip, and his friends were 18, and one of them unfortunately broke his collarbone, and it was during COVID, and he went back, and they said, you can wait out here.
Yeah.
And nobody had a medical power of attorney. I mean, and so you don't, and a HIPAA release, right? And so if your child, and I don't like to be doom and gloom, but gets in an accident and they're out of town,
Yeah.
and you don't have that, they are not talking to you.
Yep.
Until you get your body to New York or to wherever it is, they are not going to talk to you on the phone. So we do a durable so that you could help them with their bank account if they were to have an injury or have something going on. So, durable and medical power of attorney. We'll do a little small package for college kids, so that they will have those. And in fact, I have one coming in at 10 o'clock tomorrow morning who's graduating in May, just turned 18.
Yeah.
And so she's signing those so that she'll have them for college. Yeah.
Sorry, I'm not trying to stress anybody out, but I mean,
Yeah.
like,
Yeah, it's really,
yeah.
it's really, people don't, they're like, oh, I'll just be able to help my child, and that's not always the case, because they're an adult.
They are.
So,
Even if they don't act like it all the time. I mean,
yeah.
Not my children.
not my children,
Yeah.
both, but my children. Sometimes.
Yeah, exactly.
Okay, so tell me about generation skipping trust. Tell me about the crazy stuff. Tell us some really wacky
I'm
stuff.
not actually a really big, we don't do a lot of generation skipping tax type of stuff because right now, and I should have mentioned this, but the current, so just like in Texas, we don't have income taxes. We don't have inheritance taxes. We only have the federal. So the federal state tax exemption right now is $15 million per person. So unless you have an estate that's probably right at the moment in excess of $20 million, you're probably not going to run up against taxes on your estate. But again, kind of back to some of these things that people do, like if you were to pass, your children get to take your home at what we call a step up in basis. So if I bought my house for $200,000 years and years ago, and then I pass and it's $1 million house, they get to take that as if they bought it for $1 million. But when people do this thing where like, oh, I'm going to write a deed and I'm going to put my kid on the deed with me. And so they do that. And number one is, we just talked about, it does not create rights of survivorship. And I've had when the kid dies and not the parent. And now this estate that we don't even have a will for owns half of your house. But also, if you do in the normal course of events pass and then you have a will and then we're doing a probate, they don't get the step up in basis. They were already the owner.
Oh, right. Good.
You didn't.
Good
They
point.
didn't get it by reason of death. You get, or you gave them the whole house now. And of course, there's also gift tax complications with
Yeah,
potentially
for
doing that.
sure.
But those, I just did. I was, about to die, or I thought I was, and I deeded my house to my daughter, or and then they don't die for 5 years, and they don't get that step up in the basis because the transfer was not by reason of death.
Yeah.
It was they just did it at another time.
Interesting.
Yeah, so there's, I mean, we don't do a ton of taxes just because, A, I'm not a CPA, I told you about the numbers. But B, we don't need to because we rarely have an estate that obviously is going to be in excess of 30 or 15 or 30 combined. And then it's going up every year. So like next year, I think it goes to 15.9 or 16, it's progressively increasing. So
But
hopefully none of us have to worry about
Right.
inheritance taxes.
Yeah. But a good pro for the consultation, right? Because those are things you talk through and just make sure that
Exactly.
dot the I's cross the T's.
Can I ask you?
Yes, for sure.
So a very common question that we are asked from buyers is, do I need a deed with rights of survivorship because we are a community property state? And most lenders don't want that verbiage on the deed of trust or on the deed, I mean, for foreclosure reasons and
Yeah.
So do you, in your opinion, being a Texas attorney, feel that it's necessary for buyers that have the option to have that verbiage for the rights of survivorship in the deed itself when it's going to be their community homestead property?
Yeah, so I think that answer is, it depends. Is that really what you want? Number one. I mean, is that really your intention? Also, number two, the biggest mistake I see with that is I see that they have a grantor and they have grantees and they say survivorship. The grantee has got to sign that deed. You cannot create right of survivorship in Texas unless the grantees have agreed. And so I see where somebody tells the title company, they go, make us rights of survivorship, and they do, and the deed is not signed by them.
Yeah.
And so that actually didn't create any rights of survivorship, but that's a legal technicality.
Yeah.
And so I guess my bottom line would be, most title companies also too aren't having necessarily the grantees sign it, although I guess they could. I just would worry about, like, going back to like the liability of who has advised these people, and they say they want it, but have they thought about that whole situation I was talking about with the wills? Like, if they had different kids, and sure they want their spouse, but then what they don't realize is that spouse's will, then could give all of it over. So there's so many trickle downs to that to me, and I think that's why most title companies don't do it, because they don't want to, they're not estate planning firms, so they're not wanting to talk about all the trickle down ramifications, of that.
We don't advise,
Yeah. And that's why, that's why I think it's just because they really need to talk about what their entire, what is their entire portfolio? What is, this is just one asset in an entire big picture.
And with that being said, a will, especially when it's probated, can certainly supersede a deed with rights of survivorship, right? Or it depends on the situation.
No, if the rights of survivorship was done correctly and it was signed by both the parties and there's an agreement, that would supersede the will. It would make it non-probate, and then the non-probate would take precedence over. So that's why when people are doing a transfer and death deed or a ladybird deed, they're wanting to maybe never even probate their will because they are doing that transfer in an automatic non-probate, fashion. So, yeah, no problem.
And by the way, I love you for telling everybody in here that when you have a trust, you have to have a bank account with the name of the trust on it. I love you forever because so many people are shocked.
Or open one to put the money in when you sell the house. Yes.
Because so many sellers, Molly and I have seen this over the years.
Yeah,
too.
actually, we've got one we gotta work out still.
Mhm.
I'm like, oh, that reminds me,
Yeah.
we gotta get that one fixed.
Yeah, because sellers are like, well, that's me. I'm like, you're Jane Doe. You're not Jane Doe trustee of, you know.
And it's super easy to go get one, and they can show them their trust and do it. But yes, that's that whole, you know, they didn't necessarily need it before, but yeah, at some point, if there's a check that's from a sale of something from the wagon,
Yeah.
the check is going to go to the trust. Well, you have to deposit that check somewhere. And it's very easy to open a checking account with a trust or investment account, brokerage, whatever.
Yeah. We've just been told over the years that. So my attorney.
Yeah.
My attorney did.
My attorney said I didn't have to do that.
Well, we have a big old kind of a memoranda that it's about 10 pages long when somebody gets a trust of like how to deal with, you know, houses, insurance, all these things, you know, because then the first step is if they call, and I'm not answering the phone, right? It's right now someone else's, and then they go, oh, have you looked through that? It might be like on page 8, and then they're like, oh, but you know, or if they say I didn't tell them, I'm like, no, that was on page 6.
Yeah.
We told you. We gave you kind of your manual of how to be a trust for the rest of your life, because that's part of it. Is I create it today, and then you go and you live life. So again, are you going to continue to remember to, you know, put the things, you know, in the trust, which we give you instructions, and that's like leading the horse to water. So, you know, hopefully you follow those and make it work.
One other thing on probates, a common question that we hear that maybe you guys are curious about. Average price of probate, average time frame. Of course, that depends on discovery and what all the inventory has.
Yeah.
But if you can just give like a broad.
So it really just obviously depends on, like, if you're to ask, like, a will that is written by an attorney that says independent administration, like, you know, all the beneficiaries are alive, you know, all that kind of stuff, you're probably looking at around $3,000 of attorney's fees to start. And then the filing fees are going to be around $600 with the courthouse. There are some where it could be a surviving spouse or, you know, something else that might be like a little bit less because there's only one beneficiary. Or again, if you've gotten the handwritten will, or you know, that could go. Also, if you have 29 beneficiaries, I have to create a notice for every single one of those. So like that average price includes 3 beneficiaries. So again, if I've got to create 17 more pieces of, you know, so kind of, you know, and again, that main one includes like one homestead. If you have to write 6 more deeds because you have that big of an estate, there can obviously be, you know, but when people are just trying to do the math of like, should I have a trust now? Then the thing would be, you know, hey, later, can you save, like that's the rate, but what is the rate, you know, in 20 years from now? Maybe a probate's going to be $8,000. So if I have the trust now and I'm done, like with those funeral expenses, you know, so I don't know what the price of the probate is going to be in 20 years from now.
Yeah.
So that's what they're trying to say. And also appearing in court and, I mean, you know, a few other things.
Yeah, making it easy for the people.
We try to we have an entire team in our office. There are 3 attorneys. I am not the only attorney. Our other attorneys are awesome. Our staff is awesome. And we just try to make it as easy as possible. Like, sign here, show up here on this date. It's going to take 30 minutes. Okay, come back and sign this form, so that we're leading you through it like as easy as possible. So I'm not trying to make people say like probate is this horrid nightmare. And then again, depending on how many beneficiaries and things, we have a really easy county. Well, Williamson County doesn't have a big backlog, whereas if you were in Travis County or Bexar County or Harris County, but I would say probably 60 to 90 days if there's not a complication with a beneficiary or some other, you know, with the will or with something else, a normal will written by an attorney, independent administration, all that, you know, you could probably be done between 60 and 90 days.
Thank you so much.
Yeah.
Because that's something
That's
that
good.
we are asked quite.
Yeah, that's really good perspective, right?
Yeah.
'Cause-
Yes, yeah, and you know, and sometimes we know like suddenly someone passed in the middle of, you know, and so sometimes we can, you know, it has to be on file for 10 days plus the following Monday. That is the law. So I can never probably do one in less than 14 days. I mean, to get, or at least to get the authority to sell.
Sure.
The executive.
Letters,
Yeah.
testamentary or
Yeah.
something.
Yeah.
Yeah. So we can, you know, depends on how the moon and the stars align. And so obviously we know if there's an emergency, there's a sale on the table or something else like that, we're going to try to rush it as, you know, quickly as we can.
Good question.